Excellent. Well, thank you. Thank you all for joining. I have an opening statement and then we'll go to a roll call and then we'll start with the panelists and we'll come back with questions and answers from the committee and as well any comments from the public. But good afternoon. This briefing of the Wyoming Advisory Committee to the U.S. Commission on Civil Rights shall come to order on March 24, 2023, right exactly at 2 p.m. Mountain Time. Before we begin today's meeting, I just want to note that the U.S. Commission on Civil Rights is an independent bipartisan agency of the federal government that's charged with studying discrimination or denial of equal protection of the laws because of race, color, religion, sex, age, disability, or national origin, or in the administration of justice. In each of the 50 states, the District of Columbia, and each of the 5 territories in U.S. Commonwealths, an advisory committee to the commission has been established who are made up of bipartisan persons who serve without compensation to advise the commission on relevant information concerning their respective state. Today is the first in a series of several briefings, and we're really excited for this one that will examine potential housing discrimination in the state of Wyoming. Based on the information that we collect through testimony at these briefings, the commission, or the committee rather, will draft a report with findings and recommendations that we're going to share with the U.S. Commission on Civil Rights. And then the U.S. Commission will forward those recommendations to the appropriate federal and state authorities. I'd also like to note at the beginning of the briefing that we're being recorded for the public record and that the recording will be available on our public database. And if you'd like, please feel to contact Specialist Liliana Schiller, who is at lschiller@usccr.gov if you wish to obtain those records. So I'll go ahead and call the roll for the committee members. I note for the record that Valerie Thompson-Ebanks is with us, that Sally Sato is with us, that Jimmy Simmons is with us, that Gail Ridgely is with us. And let's see if I've missed anyone else on the committee. No, I think that's all the committee members. And then as well, we have our staff, Kayla Fajada, who is our federal designated officer, Angela Orico, who is our specialist intern, and then Liliana Schiller, who's our support specialist. So that's the folks with us today. Okay, today we're going to hear from experts focused on housing and the housing market in Wyoming, as well as potential housing discrimination issues they've observed through research and work. For our presenters, please feel free to go ahead and spend, say, 15 minutes doing a presentation. If you can't quite get through all the important talking points, feel free to reserve some for questions. After the presentations, I'm going to go around to each of the committee members and ask them whether they have questions for the panelists. We'll go through that, and then finally we'll end with public comment. The Q&A session is reserved for committee members only, but we do invite members of the public and anyone else is on the call. Feel free to use the chat box that's on your screen to make a comment and to share your perspective about the topic. And then at the end, as I say, we'll ask for public comment and we'll ask you if you have any to please feel free to do so. With that said, we'll begin today's meeting and we'll hear from the following panelists. And let me begin, of course, by saying we very much appreciate the time you're going to spend with us. We're really excited to have you both present. I think it's a terrific way to begin this first discussion about things that we should consider for potential housing discrimination in Wyoming. And it couldn't really be a better way to start. We have James Whiteside, who's Director of Region 8 of the Office of Fair Housing and Equal Opportunity at the U.S. Department of Housing and Urban Development. And we have Dr. Ann Alexander, Vice Provost for Strategic Planning and Initiatives, Academic Affairs at the University of Wyoming. We're going to start with Mr. Whiteside and then next ask Dr. Alexander to present. And then after the presentations, we're going to go to questions from the committee. And you'll see that Liliana has put on the screen the bios for both Mr. Whiteside and Dr. Alexander. Again, thank you so much for joining and spending time with us. It really is a terrific way to start. May I ask Mr. Whiteside if you'd start, please.
Thank you, Mr. O'Brien, and good afternoon, everybody. I am the Director of Region 8 for the Office of Fair Housing and Equal Opportunity. If you hear me slip into acronyms, you might hear me say FHEO. That's for the Office of Fair Housing and Equal Opportunity within HUD. As the director of Region 8, what does that cover? That covers 6 states in the Rocky Mountain region, and that's how HUD describes us: Colorado, Montana, North Dakota, South Dakota, and Utah, in addition to Wyoming. I thought it'd be helpful before I get into actual numbers regarding the discrimination issues that we've seen in the state of Wyoming or that we've investigated, to give a little background regarding what the Office of Fair Housing and Equal Opportunity does. Since HUD has been delegated authority to administer and enforce the Fair Housing Act, we have a large fair housing presence in each state. And so that's why I think it'll be helpful to give a little context and background about what FHEO, or the Office of Fair Housing and Equal Opportunity, does. Nationally, we administer federal laws and establishes national policies that make sure all Americans have equal access to housing of their choice. Specifically, when it drills down to our region, we're obligated and responsible for implementing and enforcing the Fair Housing Act and other civil rights laws. The Fair Housing Act applies to private and public discrimination in housing, while we also administer a number of fair housing laws that's going to apply to federal recipients. That would include Title VI of the Civil Rights Act of 1964, which prohibits discrimination based off of race, color, and national origin in federally financed programs. Section 504 of the Rehabilitation Act of 1973, non-discrimination on the basis of disability in federal financial programs. HUD also enforces in Title II of the American Disabilities Act against recipients of federal financial assistance that are public entities that receive HUD money in form of federal financial assistance. We do that through our Section 504 enforcement, as has been delegated to us by the Department of Justice. And then we're also responsible for carrying out additional statutes: Age Discrimination Act, that's age discrimination, federal financial programs; sex discrimination under the Title IX of 1972 Act, as well as Architectural Barriers Act of 1968, which relates to accessibility in federal buildings and federally financed activities and programs in public buildings. Another part of our office is I am the responsible civil rights official for the region, and I'm responsible for administering grant programs in our region as well. And we as FHEO do have 2 grant programs which we administer through the region. One goes by the acronym FAP, FHAP, that's the Fair Housing Assistance Program. And the other one goes by the acronym FIP, that's Fair Housing Initiative Programs. The difference is the Fair Housing Assistance Program, that grant program is for state and local governments that have what we call substantially equivalent fair housing laws. And I'll describe that a little bit more further. And then the Fair Housing Initiatives Program, that is for fair housing organizations. I think they're important in the context of what I'm going to discuss, because if you're looking for something that we do not administer in the state of Wyoming, it is a Fair Housing Assistance Program grant. We do not have a state or local government that is either applied for or has been deemed to have by HUD a substantially equivalent fair housing law. And we do not have any funded fair housing organizations in the state of Wyoming either. Having said that, we do have regional relationships within the state, and that is through education outreach. We conduct usually annually, especially around April. We'll have a Fair Housing Month activities in April, where we work with providing trainings, education, outreach for private industry, federal recipients, specifically the public housing agencies within the state of Wyoming, as well as reaching out and working with fair housing and community advocates on the promotion of fair housing compliance and ensuring compliance with fair housing laws. Before I get into actual discussing cases, if you mind me for a second, I'd like to take a little bit of deeper dive and to break up on how we operate, because it'll give a little context to our numbers. One part of our office, and every region has one, is called our intake branch. And that's exactly what they do: intake. They intake complaints of discrimination, but also complaints generally related to housing. So in other words, when we get information that alleges different treatment as it relates to housing or a housing program, and we review that under the laws we enforce, we look at that under a term what we call an inquiry. We call it an inquiry because we have to determine whether or not we have jurisdiction under the federal laws we enforce. A point that I'd like to make in talking about our intake branch is that when I pull the numbers for our office on geographic location, we have only received 203 inquiries that are coming from Wyoming alleging a violation or discrimination, a complaint. That 203 number doesn't necessarily mean it's jurisdictional, but only 203 inquiries originating out of Wyoming that started as an inquiry in our office. In the past 5 years, we have had only 89. That's you look at over, that's about 20 a year inquiries to our office, and that's a significantly low number in proportion. Understand, acknowledging that the state has about a population of about 570,000 people, but I consider that fairly low proportionalized. And when I talk about case numbers, I think that'll also highlight another issue to think about. And going to case numbers, another part of our office, which is primarily responsible for enforcing the Fair Housing Act and investigating complaints that are jurisdictional under the Fair Housing Act, is what we call our enforcement branch. And their primarily job is the Fair Housing Act enforcement. And when we receive a complaint of discrimination, it's in our obligation per the Fair Housing Act that we conduct an investigation, as well also simultaneously attempting to resolve it through a form of alternative dispute resolution, which the Fair Housing Act terms conciliation. So we have a dual obligation as we accept a complaint as jurisdictional under the Fair Housing Act, as does the staff in the enforcement branch, is that when we have a complaint in Wyoming that alleges a violation of the Fair Housing Act, we'll be investigating it, but at the same time, as long as that investigation is open, we'll be attempting to settle it through conciliation. Now, something to note, I'll use a term later to discuss cases in Wyoming about in which we have issued a charge of discrimination. A charge of discrimination originates out of a determination of reasonable cause at the conclusion of an investigation. Reasonable cause to believe that discrimination has occurred. So reasonable cause to believe a violation of the Fair Housing Act has occurred. If that case is then resulting in a charge of discrimination by the department based off of that reasonable cause determination, then there's two paths in which the parties can choose, and either one can choose it. They can elect to go to have the court, that case filed in federal court or litigated in federal court, or before an administrative law judge. The difference being federal court, that means the Department of Justice will take over the claim, file the complaint in federal court, and litigate it on behalf of the complainant. If it goes in front of an administrative law judge, then HUD will be responsible for litigating that claim. There's a third part of our office that I'll get to a little bit more, that's a little bit more harder to, I guess, probably maybe more responsive to some questions that you'll have, but it's responsible for program compliance with the civil rights obligation. So it's a program compliance branch. And what those staff members are doing is a wide range of activities, from applications for federal financial assistance, to transfers of federal financial assistance, to general compliance with fair housing laws and civil rights laws that are applicable to the federal recipients. In other words, so if the state of Cheyenne is an entitlement jurisdiction, i.e. they receive community development block grant funds, then those are the staff members that are ensuring that their planning documents and the operation of their programs are in compliance with federal financial requirements. I mentioned just briefly, and I think it's for context important going through, that under our grants management programs, Wyoming does not have a presence. So I just wanted to highlight that. And under the Fair Housing Assistance Programs, that's the grant that provides funding to state and local governments which have deemed a substantially equivalent fair housing law. I mentioned to it a little bit, but substantial equivalence is a certification made by the department. The first thing that happens is that state or local government applies for certification from HUD. And the key component is that the determination is that the law that will be enforced provides the same substantive procedural rights and remedies that the Fair Housing Act provides, as well as the same rights for judicial review. And then after a state or local government receives certification regarding that law, HUD will then refer complaints that originate with the department to that state and local government. So the example being, under the Fair Housing Act is amended, that this FAP program, this Fair Housing Assistance Program, when there's a substantially equivalent state law, that agency then has jurisdiction over those complaints. So HUD refers them, as well as they accept complaints under their fair housing law, and then HUD pays them for the investigation of those complaints. The program, which I mentioned, FIP, Fair Housing Initiatives Program, again, Wyoming does not have a presence for a fair housing organization within the state. And there's a variety, there's a public-private enforcement grant that we provide. There's an education outreach grant. There is a capacity building grant, which allows organizations to essentially build the capacity to administer that grant. But in the past 10 years, we have not received an application from an organization in the state of Wyoming. The last time that there was presence under this program within the state of Wyoming was actually an organization which we fund under the program in Montana, Montana Fair Housing. They conducted activities which were not under our grant, so not operate under our grant solely related to Montana, but that they would provide education, outreach, and represent clients about, probably about 6, 7, 8, 9 years ago in certain circumstances in northern Wyoming. So I wanted to highlight again some things that I saw with the enforcement data that we have. And so this is pretty basic. I think probably the most value I'm going to be able to provide is in response to questions. As I mentioned, considering the number of inquiries we get to our office, 203 inquiries in the past 10 years from 2013 to end of 2022, 5 years, 89. And in that time, we have determined under those 203 inquiries in the past 10 years, 86 of those inquiries were jurisdictional Fair Housing Act complaints. And that's significant, 86 out of 203, because we generally nationally operate around probably about 12 to 15% over the past 10 years, as far as intake inquiries into our office, which are actual jurisdictional Fair Housing Act complaints. So it is somewhat of an anomaly a little bit to see that high of a percentage of the number of contacts to our office actually being jurisdictional complaints. So again, I don't have necessarily an explanation for that or a causation why that number is so high. It could be correlated to the fact that we're not getting a whole lot of inquiries to our office. We did have a lapse I should point this out, FHEO does not have a staff member who works out of the HUD field office in Casper. We do have good relationships, but again, I think that office now has 2 individuals. In the past, it was generally just a field office director. And while we've done outreach every year, education and outreach, we don't have a local presence in Wyoming. We're down in Denver primarily. So there's 86 cases that have been filed in the past 10 years. And I pulled up some numbers to break down what that looks like. Please give me a second here. So in the past 10 years, 86 filed jurisdictional cases under the Fair Housing Act. The highest number of cases that we have, a percentage of 72%, are disability claims. A number of those are reasonable accommodation claims. So 72% of the cases that have filed have been disability related claims. The next highest percentage includes allegations of retaliation. Oftentimes that's will be tied to another protected class basis. So when you come to the actual next level of basis of discrimination, it's 14% for cases that allege familial status discrimination. And then after that, 12% have alleged race discrimination. I would point out as well that only 3% of those 86 cases has alleged national origin discrimination. I believe with the current census figures that the state of Wyoming, I believe, is about 10% Hispanic. And so it's somewhat interesting to think about in terms of from a 10,000 foot view, kind of issue spotting and thinking of proportionality, knowing a certain percentage of the population is 10% Hispanic. We've only had 3% of our complaints in the past 10 years filed on alleging national origin discrimination. And just to give you some context of that, we had 1 filed last year. And before that, we hadn't had 1 filed since 2014. So in looking back 10 years on national origin discrimination, we had 3 cases, 1 in 2022, 1 in 2014, and 1 in 2013. Additionally, I just point out, we do have 12% of those cases include a race claim. One thing that I would say is when I think about that is anecdotally, and I don't know if this might be a question so that I might, anecdotally, we have over the years done education outreach with the sovereign tribes and their PHAs or their tribal designated housing entities about issues potentially related to border town discrimination. So individuals moving off the reservation, but that hasn't necessarily led to a number of Fair Housing Act complaints. So really, if that's an issue that's talked about or asked questions on, the most that I think I've gotten in the past 10 years more relates to anecdotes. Another thing I want to point out of those closures is that out of those 86 completed cases, we've had 3 charges of discrimination. They all occurred recently, since 2018. We had a familial status case that resulted in a charge of discrimination that had to do with rules related to families with children, so families under the age of 18 years old. That case went to federal court and settled for $6,500 in relief for the complainant, as well as a variety of public interest provisions. So that was in 2018. We had a case in 2020 that we issued a charge of discrimination on, we being HUD. That was a denial of an assistance animal. We had a complainant that alleged that they were discriminated against when they were denied emotional support animal as a reasonable accommodation necessary for their disability. That case also elected to go to federal court. So one of the parties chose to go to federal court, and the Department of Justice settled that for $7,000 in relief for the complainant, as well as a number of public interest provisions. There was also a case last year that we issued a charge of discrimination on. That case is out of Jackson, and that was for the denial of an assistance animal by a homeowners association. So that was another denial of a reasonable accommodation. We had 2 complainants, and they alleged that they were discriminated against when they were denied their accommodation for their assistance animal. It actually involved, I believe, 2 assistance animals. So you can see 3 charges. It's not uncommon if you think about the number of disability claims we've had, and the fact that 2 of the 3 times that we have issued a charge of discrimination involve the denial of a reasonable accommodation. I also pulled out the numbers for settlements. As I mentioned, our form of alternative dispute resolution is called conciliation. And in the past, we've been fairly successful in the cases in Wyoming. We settled 50 of those cases for total monetary relief to the complainants of $71,017. That boils down to a little over $1,420 per complainant. So 50 out of 89 cases, did I get that number right? 50 out of 86 cases, we have settled through alternative dispute resolution over the course of the past 10 years. And again, like I said, it's a very good means to find early equitable resolutions for complaints and resolve disputes. And we've been successful in achieving that in Wyoming. Another thing I would also point out, I mentioned we do a large number of education outreach, but also thinking about what role our program compliance branch plays, and that's the branch, again, that monitors compliance with civil rights requirements. Under those civil rights authorities, we do periodic compliance reviews in our region. That is our form of investigation without a bona fide complainant. And in 2018, we did Section 504 compliance reviews of the city of Casper, who at the time was still a recipient of CDBG funds, the city of Cheyenne, and the state of Wyoming. And all 3 of those resulted in voluntary compliance agreements. A lot of times there were policies and procedure. I think most of those cases or investigations were focused on reporting and policy and procedures related to obligations when it comes to non-discrimination on the basis of disability. Another part of my office's work is for every federal financial property that receives project-based Section 8, those properties, as well as FHA insured. So if this applies to all FHA insured and FHA programs, all those properties that go through our Office of Multifamily Housing on the FHA side. Our office ensures that each one of those properties has an affirmative fair housing marketing plan. And that is important when it comes to addressing discrimination, and that even looking at the demographics of Wyoming, the obligation of all those housing providers is to ensure that they're marketing properties and property opportunities to those individuals least likely to apply. So they have to conduct an analysis of who lives at their property, who's applied to live at their property, so who's on the waiting list, what does their market area look like, and what does their expanded market areas look like? And we don't necessarily, the expanded market area could be much broader. For example, if you're in Cheyenne, the expanded market area could come down to looking at Larimer County and around Fort Collins in Colorado. One last point, if I have the time, I pulled some additional data because I think some of the interest might be on where discrimination complaints are located. The highest incidence of discrimination complaints might not come as a surprise is the most populous areas, Laramie County, Albany County, and Natrona County. And again, those accounted for 49 of the complaints, so 49 out of 86 of the jurisdictional fair housing act complaints. Vast majority of those were disability claims, with an equal amount of race and familial status rounding out. So 37 of those 49 complaints were disability claims. And when I circling back, and I just pulled this before we jumped on, one of the things I thought might be helpful and consider, well, why do you think the numbers would be low for Wyoming? One of the things I looked at just before we jumped on is considering that number of filed complaints that we've had in Wyoming. Well, what would be if you go down just one county south of Cheyenne and you look in Larimer County where Fort Collins, Colorado is located? Understand Fort Collins is a significant sized city. They've had 92 filed complaints in the past 10 years in Larimer County alone. So it kind of was something I thought was interesting as far as thinking about having those numbers regarding the total number of inquiries, 23, and then the 86 jurisdictional complaints, which we've investigated. And with that, I'll turn it back and I'm happy to answer any questions.
Wow, thank you so much. Those numbers are really helpful, Mr. Whiteside. We will be having a question and answer period at the conclusion of the presentation, so thank you very much. Dr. Alexander, thank you very much for joining us. Would you mind making your remarks?
Of course. Thank you for inviting me today. I'm excited to be here. And I believe that my primary role is to talk a little bit about Wyoming's economy and the housing market and rental market here. Obviously, my expertise is not nearly as deep as Mr. Whiteside. So let me know if I need to move in a different direction. I'm looking down here because my notes are down here, but I'll try to keep an eye on the screen so you can let me know if I need to come back from anything. So many of you already know probably that the general outline of the Wyoming economy is that our labor income and employment drivers are hospitality, tourism, state, local, and federal government employment, natural resource extraction, to include not just oil, gas, and coal, but also trona, bentonite, rare earth minerals, helium. And of course, we do have a very large land footprint for agriculture because it takes a lot of land here to raise a cow and a sheep. Many of our workers and residents, especially in some of the towns that Mr. White was just mentioning, or in those counties, tend to be, I would say, a little more transient and or have seasonal jobs, construction work, students, and so on and so forth. So we have a fairly large rental market in those areas. And especially in towns such as Jackson, Laramie, and other places where you might see an influx of workers and or others who come at various points in time, you will start to see some of those more casual practices that might emerge that you referenced in the questions that you were seeking. So for example, our housing stock in Wyoming is very heavily skewed towards having been built in the 1970s, so 50, 60 years old. And one of the casual practices might be that it takes a lot of money to renovate and to bring up to code, to bring up to standards of technology of the 21st century. And sometimes just ignoring that might be a casual practice that you do, so that the housing becomes a little more substandard, particularly in the rental market. Of course, investing in those properties and bringing them up to code and so on makes them more expensive than for the renter. So there's a catch-22 there. In Wyoming, as you know, and as you heard earlier, no state agency is tasked with enforcing our rental laws. And we don't have statutes that bar communities from having local rental laws, nor making rental law regulation the full purview of the state. So we recently saw the legislature introduce a bill to have a discussion about bringing that authority to the state level. But at this point in time, the primary recourse for a tenant is to take a landlord to court or to make a complaint, as was just outlined. In January 2022, Laramie became, I believe, the first entity in the state to pass an ordinance outlining minimum quality of life standards for rentals and a grievance process. It requires that landlords register their rentals. This ordinance was taken to court recently. One portion was ruled unconstitutional because it did not prescribe whether it was a civil or criminal offense. And so that has been attended to at this point in time. So the ordinance is back in effect, excuse me. The judge did uphold local governmental authority to pass rental regulations. Testimony to the city council revealed something that you would probably hear in many other places with large renting populations. And that was that vulnerable populations, including those who are escaping domestic violence, are often relegated to substandard, unsafe housing situations. The student population of Laramie also testified quite a lot in the hearings leading up to the passage of the ordinance, also citing many substandard and unsafe housing situations. So in practice, not updating or renovating rental properties and allowing excessive deferred maintenance to accrue is common. And I already mentioned this, but most Laramie and most Wyoming housing stock was actually built in the 1970s. So that does have a bit of an impact on the quality of our housing stock. That also impacts buyers because it is now the case in many of our housing markets because of price increases that really escalated post-pandemic. And even during the pandemic in Wyoming, we saw a large influx of remote workers and retirees, and housing prices went very, very high. So between that and the subsequent increase in property taxes, it's very hard to be just an average working guy or gal like us to buy a house here in Wyoming. And so that's really been very difficult, I think, for owners as well, for people who hope to be owners or who are longtime residents and are now finding themselves priced out of the market. Our net migration has been especially high to Bighorn, Fremont, Lincoln, Sublette, Laramie, and Weston counties. We've seen as well anecdotally, Teton, Sheridan, Natrona, and Park counties seeing high net increases in in-migration. According to realtors that you can interview and speak with, they would estimate between 10 and 15% of the increase of home buying has been from out-of-state home buyers, and about 5% of people who were returning to Wyoming from other places. Workforce housing is increasingly hard to come by. And as I said, property taxes have escalated greatly over the past couple of years. So our housing price index has gone from a 5-year of 50.15 to at the end of 2022, 451.28. You don't need to even know what the housing price index is made up of to know that that is a giant increase in our housing prices in Wyoming, and that's across the board. So housing grant legislation was passed for infrastructure for affordable housing at the legislative session last month, wrapping up earlier this month, I guess. And so that might make a dent in some of this. But Mr. Chairman, that is what I have for you as far as my briefing goes.
Well, thank you very much, Dr. Alexander. That was just great. And again, thank you, James Whiteside, too. So this is the question and answer portion then for the committee members. And I just want to take a quick look. I want to go around the room. I know Valerie has a time constraint, and I just wondered if it's okay with the committee. I'd like to start with Valerie to the extent you have any before you have to leave. Any comments or questions you have for the panelists? Valerie may be on mute, or she may have had to step away already, because I know she had a meeting. Okay, no problem at all. Okay, so what we'll do then is go around the room and ask any of the committee members if they have questions. I have a couple that I'd like to ask, but I'm happy to save them to the end. I'm just going to go sort of in the order in which it shows up on my little list of participants here, if that's okay. And we'd start with committee member Jimmy Simmons. Jimmy, do you have any questions, or would you prefer to pass for the moment?
Well, I do have.
Okay.
I'd like to make a comment first. I worked on a case in Riverton where it seems that the attitude of the manager is we can rent to who we want, even though they're subsidized by HUD. That was one of the things, that's the attitude that I see. And the other part of it is they feel that their operations run better without too many Black people in the complex. And then the next thing is, I found that the tenants themselves want to make the determination of how many Black people live in there in that complex. It's like this. Everything was running all right until you moved in. So the answer to our problem is you move out. How do you address something like that, Jim or Mr. Whiteside?
I'm sorry. Let's unpack that a little bit. I think what my office would be, and I don't think that anywhere in our region that would be a rare allegation. I think that especially in our rural areas, we get a race discrimination complaint. They often pattern that. They're often complaints regarding neighbors. So we get harassment complaints as well.
Yeah.
And also times it's the harassment complaint is the harassment being alleged that the individual is being subjected to is by neighbors, and then the claim against a property or the property management company would be that they didn't respond to it. They failed to act. HUD actually interprets the Fair Housing Act to include harassment in the instance where third-party liability occurs, third party being, say, like a property management or owner or landlord, where they failed to promptly act and respond to that, being aware of the harassment. But generally speaking, I think how my office has a role there is someone individual contacts our office, they can contact us. Out of time, I didn't put all the procedural opportunities that they have. So in other words, they can file online, they can call us, they can send us an email. My phone number is online as well. A number of individuals contact us directly through my phone number. But we take their allegations. If it alleged discrimination on the basis of race and it met the jurisdictional requirements of the Act, of the Fair Housing Act, then we'd file that complaint and conduct the investigation. In which case we'd be looking into each of those allegations as you frame them out. I think another part of your question and comment related to a federally funded provider. I think one thing I always have concern, especially in our region, is what information that we have in order to initiate compliance reviews, periodic investigations under Title VI of the Civil Rights Act of 1964. Working in Wyoming, similar to working in some of the other states in our region where there is not a lot of diversity demographically. Oftentimes, I think we get more information anecdotally than we do through filed complaints. Information is also helpful, I say, because under Title VI, our Title VI authority, it's fairly broad in the sense that the department conducted an investigation upon receipt of any information indicating a potential violation of Title VI. So we do have broad authority here. And so I think as we unpack this a little bit, as far as, what would we do? I think in this instance, what we would be doing is we would need the information to be provided. If there's a bona fide complaint, we'd need the complainant's name, If someone's just providing us information, we need to know the property, and we did conduct an investigation. We are an objective fact finder, so we would conduct an investigation and provide the procedural and substantive rights for both the complainant and the respondent to conduct the investigation and determine if discrimination occurred. I don't know if that directly answers your question, but that describes, I think, generally how we approach those questions and issues. I think it's really important for me to emphasize with all of this, it's important for my office, and I think about this in relation to the commission, to get the information in order to conduct those investigations.
Jimmy, actually I have a follow-up question, but I don't want to cut you off. Do you have another question you'd like to raise?
No, I'm okay with that.
Okay, thank you. And I'll save mine because I do have one that I'd follow up on. I appreciate your question, Jimmy. If we could go on then, Gail Ridgely, did you have any questions for the panelists? Gail? You may be on mute, Gail. I'm just looking at the screen here. Okay, let me just move on. Sally Sato, any questions that you may have for the panelists?
Yeah, Riverton is characterized by being a racist community, and I don't know how many Black people live there, but I do know that a lot of the Native American population feels very marginalized by the residents up there. But so mostly, how do you have any jurisdiction over housing on the reservation to make sure that the housing is safe? And because I've heard stories about that, often there's not running water and the power goes out frequently.
I think this question is for me. And
Yeah, I think it is. Yep.
So for my office, we don't have jurisdiction. The Fair Housing Act, we don't have jurisdiction of the Fair Housing Act within the boundaries of the reservation, and we don't have any jurisdiction over the sovereign nation. We do have protections related to disability and HUD-funded programs for the tribal designated housing entity, so the PHA. So we do have that authority, but it's solely based off of non-discrimination on the basis of disability. When we do get those questions, we refer them to our Office of Native American Programs, which I would say both on reservation and off reservation. And I think Dr. Alexander talked about this a little bit, is habitability is one of the, when I mentioned those number of inquiries versus, I mentioned how high the percentage of complaints were, but one thing you might be asking yourself is, well, what's the difference between those people who attempted to file a complaint and the 86 ones that you filed? And oftentimes the question we do get a lot, primarily probably in the private housing provider sphere, is habitability, running water, mold, response to maintenance requests, chip paint, those types of habitability issues, just the general habitability of the property. But we wouldn't have jurisdiction over that unless the individual also was alleging that was difference in treatment based off of their protected class status. So race, color, national origin, gender, familial status, disability.
So you don't even have anything to protect the children?
Well, I think probably my limitations would be that our office, so my office, the Office of Fair Housing and Equal Opportunity, enforces the civil rights laws. So I don't want to get theoretical here, but there might be a means. But generally speaking, what we would be looking for if that information came to us or that issue came to us would be whether or not what was being complained about was jurisdictional under the Federal Fair Housing Act. Or if it's off reservation and it involves a federal property, we might look at our other authorities. Familial status is somewhat unique when it comes to children in the sense that that's a protected class under the Fair Housing Act. But I think what we would have to do is evaluate that claim, that information, to determine whether or not we had jurisdiction under the civil rights laws.
Okay, thank you. Maybe we'll ask our next committee member, Virginia Arbor. And I should have noted, Virginia, you joined the meeting, I know, very shortly after it started. So just to let the record reflect, you've been on for a long time, which is terrific. But do you have any comments or questions for the panelists?
Well, can you hear me?
We can, yep.
Okay, good. Thank you, Jim. I'm so grateful for both of the presentations. They were so thorough and answered many of the questions I came into the meeting with. I have questions about, I suppose, most of all, what is involved in the conciliation process. It seems to be a very important way of keeping things in a fruitful conversation before it has to get into some higher level of litigation or energetic oppositional conflict. And so if you could just explain to me a little bit better how that conciliation process works and how it, I guess prior to that, establishes reasonable cause. Where I suppose, you correct me if I'm wrong, you would have to eliminate other causalities for refusing a tenant or refusing a buyer, causes other than job references, ability to pay, criminal record, that kind of thing. I mean, it seems as though there's so many overlapping areas that could be causes of not accepting a tenant or accepting a buyer's offer. And how do you conciliate in such a way that you navigate among the potential minefield of causes? Is my question clear?
Yeah, I think and I can provide some clarity to potentially that rushed analysis of myself. So one differentiation here is that, so if you think about, unless a complaint is withdrawn or other sort of administrative means close the case, or we determine after investigations we don't have jurisdiction, there really kind of becomes two end paths, I would guess, say, for an investigation. And one was that conciliation, which is, it's our form of alternative dispute resolution. So we're trying to settle the complaint.
Yeah.
And then the other side, if it doesn't settle and we have to complete the investigation and make a determination on that investigation, that's that reasonable cause piece of it. We're trying to determine whether or not there's reasonable cause to believe a violation of the Fair Housing Act occurred.
Okay.
So that if we get to that point, we are, reasonable cause talked about in different ways, I guess somewhat analogous, although not completely the same as probable cause, but you can think of something like that type of standard. That's going to result in the charge or complaint, the department issuing the charge of discrimination. So it's that point in time when we've made that determination,
Okay.
that the department believes that discrimination has occurred under the Fair Housing Act, and then the department is, through our Office of General Counsel, issues a charge of discrimination. But then going off to the other side, the conciliation, and maybe just knowing that other path of it is helpful, but the conciliation process, like I said, it's not the same as mediation. Some of those skills are necessary, but it's a form of dispute resolution. And what we're trying to do is resolve the complaint. So we're not getting into causation or making determinations, and we're doing it throughout. So we haven't made a determination whether or not a violation's occurred or whether or not the denial was based off of race or based off of disability. We're just trying to resolve the dispute at hand, which comes from that complaint, which we being HUD, have already deemed that to be jurisdictional under the Fair Housing Act. We're just resolving the complaint. We're not making any findings.
Okay.
And if I take another layer here to get somewhat deeper, when it comes to the PHAs and the other federally funded recipients, when we get a complaint under Section 504, when we get a complaint under Title VI, what we also are proceeding with in those, and we're obligated by our regulation to do another form of dispute resolution. It's not called conciliation. It's just engaging in informal resolution to resolve that complaint, to resolve that investigation. So I just put that out too, there because in each of these instances, pre-making any findings, we're obligated regulatorily to resolve these complaints and by the Fair Housing Act by statute. And that's what we're operating before findings. Now with the federal financial assistance statutes, one thing that happens if we don't resolve it, we need to issue findings, we'll make findings that whether or not that recipient complied with their civil rights obligations, say under Title VI, or didn't comply. Now, if we find they didn't comply, again, what are we obligated to do? In our regulations is we're obligated to go back again and try to resolve it again. So in all these processes, whenever we have a dispute, we're trying to resolve it as well as conduct a thorough investigation.
Thank you.
Let me go back quickly to Gail. Gail Ridgely, did you have any questions? Okay, hearing none. And Valerie Thompson Ebanks, did you have any questions?
Sure thing. Thank you.
Yeah, absolutely.
Yes, I really appreciate listening to both Mr. Whiteside and Dr. Alexander with this detailed presentation where it's really informative and will shape how we move forward and perhaps give us additional areas to ask questions to future panelists. So thank you so much, really detailed. I was curious about the complaints, Mr. Whiteside, in terms of, are these complaints primarily from renters, tenants? Do you get complaints as well from homeowners?
I was looking to my side to see if I had pulled that granular level. I would say primarily they are renters, which I think is in Wyoming. I think it's something like, I don't know if I want this on test, but I think it's over 70% is homeowners in Wyoming, high home ownership rate. But it's primarily renters, applicants for renters. Some of these complaints that fall into this category, they could be as granular as saying applicants for a housing choice voucher program from one of the housing authorities. So it is primarily renters. And even if we don't have a lot of lending complaints either. We had one last year, which involved an organization that tested a bank in Gillette about their about whether or not they're responding to requests for lending. So that's fairly limited category. So primary renters, I would say, since it's recent, last year when we charged a case with the two complainants and they each had an assistance animal, they were homeowners in Jackson. But again, maybe I'm getting too detailed here in the sense that generally it's renters that come to us. And I think that's fairly common across the board, although with the West, and I know this is true in Colorado, and I think it's very true in our other states, is with the proliferation of common interest communities and new developments. So when you have HOAs and different property owners associations, that's typically where we see the homeowner complaints.
May I have a follow-up question, Jim?
Yeah, of course, Valerie.
Okay, sorry, thank you. As Mr. Whiteside, as you mentioned, lenders, I thought about discrimination in house or home appraisals, which has led to devaluation of some persons' homes. Do you get any, have you gotten any complaints in that nature?
We haven't in Wyoming. The only thing I'd add is some issue that we have, I guess I would put this under the category of what we would like to do in education and outreach, is we've had from other states in our region that have had more presence with Native American reservations is that we've had the issue, and like I said, sometimes this is anecdotal for us, but it's something we would like to look into as far as education outreach is even within the boundaries of reservations or even near the reservations, there's fee simple property that's owned with single family homes on it. And so the issue has been discussed to us, and we've had some complaints in the Dakotas, is the ability to get an appraiser at a rural property. And then how it would be jurisdictional for us is rural property and oftentimes on or near a reservation involving an American Indian household. But I know that doesn't answer the question directly. It's we haven't had many lending cases, and we haven't had an appraisal case in Wyoming either.
Thank you.
Okay. I have just a couple of quick questions as well, and then we'll go back through with the committee and ask if anybody has any further ones. Maybe one for Dr. Alexander. I mean, it's clear, I think from the numbers, at least as you laid it out, housing is dear in Wyoming. And I wonder whether, particularly when you think about rental housing, and I wonder whether the numbers that that Jim Whiteside talks about may be due to the fact that someone who's renting or trying to rent becomes concerned about whether or not they would be known as a bad renter if they went and complained about discrimination. And I don't know if you can give us any thoughts from the numbers you've seen, whether that kind of dynamic exists.
I think that's an incredibly astute observation. As Mr. Whiteside said, our owner-occupied home ownership rate is in excess of 70%, and so the fact is that our housing is quite dear. And if you are, I'm in Laramie, so I'll just continue to use a student in Laramie. If you're known as a sort of disruptor who went and complained, it's a small community, and the landlords all tend to know one another. There's also been at least locally here, and I think this is also probably true in a couple of other markets, that when people are viewed as the problem tenant, you might end up having your landlord approach you and say that you are now you're occupying an Airbnb, and we're taking this out of the rental market. So that is a very astute observation. I did want to also just give you some data. There was some discussion about the standard of housing and so on. About 2% of households in Wyoming do not have hot or cold running water. About 3% of households in Sweetwater, Fremont, Uinta, Sublet, and Hot Springs, including the Wind River reservations, do not have hot or cold running water.
Wow. Thank you, Dr. Alexander. And then a follow-up question for Mr. Whiteside. It really goes on, I think it's consistent with Jimmy's question. That is, as I think about these numbers, 86 out of 200 approximately, as you point out, seems like a large percentage relative to the others. So what it seems like is that there are fewer people that bring complaints, but when they do, at least on a percentage basis, more of them have merit. Do you think that any of that is due to the fact that somebody in Wyoming has to sort of go, in their minds anyway, have to worry about going all the way to Denver to sort of make their complaint when they don't have anybody locally in Wyoming that they can make their complaint to? When you look at these numbers, you might think that the complaint numbers would be much higher in order to end up with on the order of 80 valid complaints. Any thoughts on that?
I think that's something I think about that. We do have a good relationship with our field office. So, and it's not uncommon in HUD, and it wouldn't be uncommon if they call the director of the Wyoming field office for HUD to state a claim of discrimination, whether it was Mr. Fellmeyer now or his predecessor, Lyle Conkle, and they would refer them directly to our office. But I think it's, again, this is anecdotal, but it's something that we hear a lot in our region, whether it be Wyoming, Montana, North and South Dakota, of whether or not there is some sort of barrier, because we are a region, and I guess the analogy is the Colorado Rockies are the only Mountain Time Zone baseball team. Is that everyone's in Denver. And so we're very Denver centric. And so I do think that's something that we can think about and get concerned about, especially coming out of the pandemic, in which we didn't have the opportunity to travel to the state to conduct investigations for a very long time. And when you decrease that presence, what's the opportunity to be able to understand that when you have a housing discrimination complaint, you contact HUD? Having said that, I don't know if our numbers were that different during the pandemic as far as filed complaints as they were in the bookended years. One thing while we were talking, just to highlight the difference, is that in our 6-state region, last year we filed 233 complaints. And that's 233, and you think of Wyoming over the course of 10 years being at 86. So that kind of, again, highlights, is this a proportional number? And I didn't dive that deeply into it. But I do wonder, I do consider that. And, thinking about where the highest number of complaints are, right? I mean, we talked about it. They're going to be coming out of Cheyenne. And Cheyenne is the closest to Colorado, the closest on I-25 to Denver.
And thank you very much. And just one other quick question, then I'm going to turn it back to the rest of the committee. You mentioned that that one way in which there's funding available for things like the potential local enforcement authority is if the act or the laws in Wyoming are substantially equivalent from a fair housing perspective. Wyoming has a Fair Housing Act. But one thing that isn't in for the Wyoming Fair Housing Act, at least at the time it was passed in 2015, is sexual orientation. Is that a necessary item for the Wyoming Fair Housing Act in order to be substantially equivalent for a federal, the Federal Housing Act?
So to answer your question, HUD does interpret the Fair Housing Act consistent with the Bostock v. Comstock County decision, which has gender, sex discrimination covering sexual orientation, gender identity. So in operation of the FAP, in what we call the FAP program, a state or local government, because they have to have the substantive rights protected under the Fair Housing Act, and HUD interprets the Fair Housing Act to protect under sex discrimination, sexual orientation, and gender identity. The agency that was enforcing that law would have to interpret sex discrimination to include those protected class categories. It doesn't have to be carved out individually. Many state governments and local governments in our program had already had articulated protections for sexual orientation and gender identity. So it doesn't have to be specifically enumerated. It's the interpretation of sex as a protected class to be consistent with the Bostock v. Comstock County decision and include sexual orientation and gender identity.
Great, thank you, Ms. Whiteside. Let me go back quickly then to the committee one more time. Jimmy Simmons, any follow-up questions that you have?
I had one question about when you a HUD guaranteed loan on a mortgage. When those mortgages are sold, is that guarantee still in place?
So are you referring to it? The simple answer is, I don't know. I don't administer the FHA programs. So I was going to ask, is there anything about FHA insured loan, but probably the answer from the HUD person here is that I don't have the answer to that. I don't administer the FHA programs to speak on it.
Okay,
Thank you. And looking down, I'm just getting my list. Virginia Arbery, you're next on my list as I see it. Any comments or questions you have, please?
Okay, so relative to your probe about the Wyoming law on fair housing, not including sexual discrimination following Bostock. So, and then my understanding from your answer, Mr. Whitehead, was that it doesn't matter. The state still has to comply with those court rulings. Have we had any I didn't hear you mention any sexual discrimination complaints that came into HUD in those 200 cases over the 10-year period. Or were there?
There were. So
Oh.
about 9% of our filed cases in Wyoming included a claim for sex discrimination.
Oh, really? Oh,
Now, what I'll say is the Federal Fair Housing Act and HUD interprets sex discrimination to include sexual orientation and gender identity. That's just, that's how HUD's going to enforce the Fair Housing Act. That is separate and distinct from the state or local governments and their laws. If somebody, I mean, I will say in some in Wyoming alleged on the basis, and it was otherwise jurisdictional, a complaint alleging discrimination based off of sexual orientation and gender identity, we would accept that and investigate it.
yeah. So if I'm understanding this correctly, then it doesn't make any difference whether Wyoming ramped up its law to include categories that it's left out in its fair housing bill, because still renters, landlords, homeowners, etc., are subject to the national law.
Yes, they're subject to the Federal Fair Housing Act.
Okay, thank
Yeah.
you.
Can I just to clarify, my question was around the availability of federal funds for like the FAT program. I think that's a little different than what you're speaking about, Mr.
Oh.
Whiteside, right?
Yes. Yes, and that HUD's going to enforce the Fair Housing Act because that's what we're obligated to do, separate from a state or local agency enforcing a law. But to be in that FAT program, they'll have to substantively provide the same substantive protections as the Federal Fair Housing Act.
Yeah. So it was just to clarify, Virginia, I was actually asking about getting federal money. That was the point of that one.
Oh, but it made me think about the other things. So thank you.
Yeah.
Thanks.
Okay. Anything, Gil Ridgely, you're next on my list. Any questions you have? No? Okay. Sally Sato. Sally, any additional questions you have?
No, I'm fine. Thank you.
Thank you so much. And then finally, Valerie, did you have any follow-up questions for the panelists?
I do have a question for Dr. Alexander. So Dr. Alexander, I do know that students over the years have had a number of complaints, and I'm curious if you're aware of any document with these complaints, compilation of these complaints. Is there any document that is public that we could access, anything of the sort?
I believe that what I might suggest is looking to the testimony that was given during the Laramie City Ordinance discussions. Many students, including ASUW representatives, associated students at the University of Wyoming, were present and brought their stories to the council to argue for the rental ordinance. So I would, I definitely took a look through several of the newspaper articles and some of the summaries of the testimony from there. But many complaints were to the effect of mold not being remediated, vermin of various types not being remediated, and then basic non-maintenance of things that you would expect should be working in your home, such as heat, water, and in some cases, kitchen appliances and so on. But heat was one of the bigger ones. So I would suggest looking to some of the testimony provided during those hearings.
Thank you. That's very helpful. And so broadly speaking, Mr. Whiteside, some of the areas that Dr. Alexander just talked about, would those fall under the jurisdiction of discrimination, or that would be different?
Yes, there could be some overlap,
Okay,
but it would have to, the individual would have to be alleging discrimination because of their protected class status. So they would have to draw that connection of why to the because, and the why, because being their race, their color, their gender, their disability status. And that's often, you know, we do, there are jurisdictional, oftentimes there are jurisdictional complaints which have to do with issues that are very similar. You know, like I think that the common would be if the issue was tenant A doesn't have hot water, tenant B does have hot water, and they're different races.
I see. Thank you.
Excellent. Well, thank you, panelists and committee members. I want to move then to public comment. This is an opportunity for the public to offer comments to the committee about the topics we've been just discussing. If you have comments, please limit them to 2 to 4 minutes, just because we'll be a little short on time. We've got some other matters to consider. But I'd like to ask, is any of the people who have been kind enough to join, who I actually see on our list here, would like to make any comments? I see Lori, your hand is up. Lori, would you like to start?
Yes, thank you so much. I'm Lori Urbakite. I'm with the Wyoming Realtors. I'm their Government Affairs Director, which is the long title for lobbyist. And I personally worked very diligently in 2015 to get our state Fair Housing Act passed. And the goal was always to work with HUD and to access the funds that were available to have some agency, some entity in Wyoming take over the enforcement of it. So we didn't get very far with that. The way the language was written, it's up to the governor's office to determine where it's going to be housed. And the governor at the time, Governor Meade, did not move forward with it. And it was our commitment that we would continue to work on it. And with a new chief of staff in Governor Gordon's office, we have already started the conversation with the chief of staff that we want to have a sit down and get very serious about this. We believe that not only the landlords, but the tenants, the buyers, the people that are alleging discrimination would be better served if indeed there was a place in Wyoming that they could file their complaints. Not that I'm certainly not saying, Mr. Whiteside, that you don't do a great job. I mean, I don't believe that at all. It's just a matter of, we kind of like to do things in Wyoming. So we're going to continue to work on that. And I just wanted to be really clear, when we wrote that legislation in 2015, it was substantially equivalent to the Federal Fair Housing Act. We had it reviewed by someone at HUD, and they said yes. In fact, they told us to plagiarize North Dakota's act, and so we did. And we fought very, very hard not to have any amendments added to it or deleted or anything. It does not have sexual orientation in it. If the entity that ultimately is in charge of enforcing it, as long as they understand that that is part of the enforcement, do we have to amend that bill? I mean, I need to be real clear on that, because I'm not going to go beat the governor up if we are not going to be substantially equivalent without amendments.
Generally, I think public comment is just comment, but I'd invite Jim Whiteside to respond to that, just to be clear.
The protection.
Yeah.
So the statute
was reminding me the public can't ask a question, so I'll just.
I'm sorry. I apologize.
That's okay, Lori, but because it's an important question, I think we should just be clear. So Jim, the question is, do we need to amend the statute in order to be able to get the federal funds to enforce it, or can it be done as I think you suggested, and that is that the enforcing entity takes a view that sexual discrimination includes those additional classes?
So you want me to answer the question?
Yeah, please, if you don't mind, that'd be great.
So the statute does not have to be written with the verbiage, sexual orientation, and gender identity. What's to be substantially equivalent, the statute has to provide the same substantive rights. So the Federal Fair Housing Act provides a substantive right that sex discrimination covers sexual orientation and gender identity. That is what needs to be, and in executing this, and some of this is outlined on HUD's website. When once the application and once HUD certifies a statute or ordinance is substantially equivalent, there'll be the entry into a memorandum of understanding between HUD, so between the federal government and that state and local agencies regarding the enforcement of that law. And so that will establish that the state or local agency will enforce their fair housing law to provide that substantive right that sex covers sexual orientation and gender identity. The verbiage doesn't have to be there. In other words,
Okay.
it's the interpretation and application.
Okay,
Wonderful.
Thank you,
And
Ms.
then
Whiteside.
I'll just follow up and say that the Wyoming Realtors are committed to fair housing, and we will continue to work with the governor's office to see if we can't make this a reality in the next, coming year. It's a big lift, but we're going to give it our best shot. And I thank you very much for the information and for allowing me to listen in today. Thank you.
Well, thank you for joining us, Lori. I really appreciate it. Other comment from the public? Anyone else? I don't see any hand raised. Okay. Well, that was a terrific first start. Really wonderful. We really appreciate your engagement. Both Jim Whiteside and Alexander, thank you so much. I know everyone's busy. Lori, thanks for those comments. That's very helpful. We're going to move on to some committee business quickly to cover off on our second panel. So you're welcome to stay on if you'd like, but no need to do so. Again, thank you. And I think what a terrific kickoff. So thanks again. So we have, thanks again, we have 5 members of the committee, which is terrific. I want to make sure before, I know there's some tight schedules, and before people leave, we go ahead and vote on our next panel. Because I, as you can see, Kayla, Liliana, Angela did terrific work in lining up just a great start for this panel. And I know they need our vote in order to be able to take the second step. I don't want to at all get in the way of discussion. If Kayla, would you stop sharing your screen for a second, and I'll share my monday.com screen, if you don't mind, just to make sure everybody sees the panels.
Sure, give me 1 second. I think I might have to give you privileges, so give me a second.
Oh yeah, you did. Yeah.
Okay, there you go.
Okay, excellent. So we have on monday.com, of course, was the oh gosh, I had it right here now. Where did it go? We had the list of folks that we were going to potentially consider. Well, let me just share my email, because I went ahead and just looked through and wanted to suggest to the committee that these 4, Jason Wells, Melissa Ray Thero, Raymond Machia, and Bria Frame, be the sort of first priority list, along with backups and Brenda Burkle and Dan Dorsch. Those are the ones after I'd read through it that seemed appropriate, but I wanted to make sure that everyone has a chance to comment on it. Anybody have other thoughts and ideas? That would be terrific. I know I had monday.com somewhere on my screen here to share with everyone, and I think I've goofed. I must have closed it, so apologies for that. But any thoughts and ideas, whether people have a different idea on who our second group of panelists should be? Any thinking or thoughts?
Are these government officials?
No, these are generally sort of community activists and those concerned with housing, Jimmy.
Okay.
We'll have a panel, I think, for government officials that will come up a little bit later. I particularly wanted to give, like, as an example, the governor's chief of staff an opportunity to come and talk, and perhaps can talk about this whole idea of Wyoming enforcement. But this would be generally the community advocates would be on our second panel. So while you're looking, I will quickly, Kayla, you don't happen to have the monday.com
I
handy, do
do.
you? Okay,
I
then
do.
I'll
I
stop
can share
sharing.
my screen. Yeah, no
Okay.
problem.
Super, thank you. Let's give everybody a chance to see it. By the way, that was really a great start. I really appreciate the committee members, everyone joining. So here is the group of folks, community advocates. So, and I should have mentioned, Jimmy, I'm anxious, of course, for Mrs. Groves to come to the committee. I'm hopeful that we might save Mrs. Groves to perhaps our third briefing after we've kind of had some background information, and that'll give us a better chance to hear her story. The other thing I'd like to do is to see if we could get any other people who might be able to give us sort of a personal impact story who could come and speak to the committee. So that was my thinking. I don't know if that's consistent with yours, but that I thought it might be better to have her along with others as opposed to just with a group of, you know, kind of community advocates. But give us your thoughts.
Well, I think that as long as we have her on there and the group have an opportunity to really hear what firsthand what she's going through in these federally funded facilities. I just feel that everyone needs to hear her story.
You know, fair enough.
So if it's the second group or third group, it doesn't matter. Just as long as we get her on there and you know, you get familiar with the nightmare that she's been going through. And you know, she's looking to a civil rights organization and the police department to try to help resolve this. And you know, my advice to her, you've got to go through whoever's financing this thing or whoever's backing it, which is the federal government.
Mm-hmm.
You have laws
Yeah.
against what's happening to her.
And sorry, I didn't cut you off. I just
No, go
want
ahead,
to
Kayla.
offer a
Yeah.
solution. Jimmy, if these briefings are open to the public, so if at any point too that Mrs. Groves would want to attend this briefing as a member of the public, she can certainly provide her public comment, her story during public comment at the next briefing or at any other future briefings.
Okay.
Good point, Kayla. Yep. Thanks for reminding us. Yep.
Yeah, no problem.
Okay. Well, those are the folks you'll see that I had suggested a group, sort of the initial group, Jason Wells, Melissa Ray Therout, Raymond Machi and Bria Frame, and then our backups being Brenda Burkle and Dan Dorsch. That would be panel 2. And then, of course, Mrs. Gross could be in public comment, and I'm certainly going to be in favor of, at the next one, specifically inviting her if she doesn't appear for public comment, and we can all talk about that. But for this next panel, those would be my recommendations, and happy to any other modifications. Any other committee member want to change or switch? Yeah, don't be bashful because there's no pride of authorship. If people feel strongly on any one of these other ones, absolutely, let's hear from that person instead. Okay, hearing none, then could we, is it okay if we had a motion to approve as our next 4 panelists, the ones in my email, Jason Wells, Melissa Ray Therout, Raymond Machi, and Bria Frame, and then have as backups Brenda Burkle and Dan Dorsch?
I'm so sorry, Jim. I don't mean to interrupt, but I wanted to offer an alternative for your, well, that's
yeah, go ahead.
Yeah,
go ahead, Kayla.
The alternatives that you listed, I would like to add the individuals who you guys voted to approve for group 1 who weren't able to make it. because of scheduling conflicts. A lot of them weren't able to make it because of their schedule. So if they might offer another, useful perspective, just as an alternative in case there's, any issues with scheduling again with these members of group 2, just having them on, a big pool of alternatives to pull from might be helpful.
Well, great suggestion, Kayla. So maybe, we had previously asked to hear from those group 1s. Maybe we should say priority would be the particular group 1 folks that we ask about the first time, and then priority 2 would be the additional ones from group 2 that we just listed out, and then priority 3 being the 2 backup. Does that make sense, Kayla?
That does, yeah.
The rest of the committee, people have thoughts on that?
I can't remember who the first group was.
Can you put group 1 back?
Sure
So
thing.
just scroll down a little bit, if you don't mind. So I think we had Peter Christensen was on our list.
Mhm.
Yeah, Peter, and then there was the HUD individuals. I believe the Corianne was an alternate as well as Lance.
Right. But I think Peter was somebody that we were thinking would be a great candidate because of he's
Yes,
done a large scale study on housing discrimination, might be able to provide sort of a broad perspective.
yes,
Oh,
I
and then Mary,
actually,
right?
yeah, and I actually connected with him. He reached out very recently, so it was too short of a time frame for him to prepare any remarks today. But he was gonna submit written comments, so I might just tell him, we do have another briefing coming up if he's able to make that one. He certainly can attend.
And Mary Therese Gorski as well, because she was going to speak to Native American populations. I think that was something they were very concerned
That's
about.
right.
So those are the 2 priority ones that we had. So I'd
Gotcha.
suggest Peter and Mary Therese, and then moving to our group 2.
Okay, yeah.
After that.
Sounds good to me.
Rest of the committee, folks.
Sounds good to me too.
Okay, well, if it's okay, could I have a motion approving that approach? Peter and Mary first, and then the next 4, and then the final 2 as alternates.
So moved.
Thank you, Jimmy. Is there a second?
A second.
Thank you, Virginia. Appreciate it. All in favor, say aye.
Aye.
Opposed? Motion passes. Terrific. That's great. So we have our second panel lined up. Can I just finish quickly by saying thank you so much to Kayla, Liliana, and Angela for great work. You might have heard at the beginning, it sounded a bit written as I read those introductory remarks, because it was. And Kayla and her team prepared those to make sure that I said all of the things that we were supposed to say as part of one of these things. So I really appreciated that as well. So really well done. Thanks for your help. It makes it so much easier.
Great job, Jim. Thanks.
You bet. Unless there's anything else, we'll call ourselves adjourned and look forward to seeing everyone again in May. Thank you so much for attending.
Y'all have a happy Easter.
Thank you. You too. Thanks,
Okay.
Virginia. Happy
Hope the
Easter.
snow stops.
Thanks, bye now.
Uh-huh.
Bye.
Thank you.
Bye.